Welcome to ALP Corner, Family Law in the Heart of Houston.
Welcome to ALP Corner, Family Law in the Heart of Houston. I'm your host, Abigail Vaca, and today I'm joined by Allecia L. Pottinger. Thank you for joining me today, Allecia.
Thank you, Abigail, for having me. I really appreciate it.
Let's get started. Can you explain how child custody is determined in Houston and what factors the court considers when making a decision?
Well, there's a whole long list of things that go on when you're talking about child custody. And let's get started. There's three ways that a court may look at child custody. First, they may, one, appoint an amicus attorney to represent the best interests of the children. An amicus attorney will go from each house, talk to the kids at each house, come up with a determination of what the children want, and report to the court what they believe is in the best interest of the children. The other thing is that you can have a custody evaluation. That custody evaluation in some counties is relatively inexpensive. And the same thing, they go to both sides. They delve into grades. They delve into backgrounds of the parties. They do a very in-depth, detailed report and go into all the criminal activity that another party or this party may have, and to make sure that this is in the best interest of the children. They make a report. Typically, it takes about 90 days to get a report back. And at that particular time, that report is filed with the court, and it lets the court know what they feel is the best, in the best interest of the children. The last step is that the judge or jury can decide what's in the best interest of the children. Now, in case law and in what we as practitioners know, we heavily rely on Holly factors. And Holly factors, how we get to the Holly factors, it was a case involving a Holly person, and the Texas Supreme Court delineated what are some of the factors, key factors that someone should look at or the court should look at when they're determining what's in the best interest. First one that you start off with is, what is the desires of the child? What are the resources that are out there to aid the parent in actually parenting? Which one is going to foster? Remember, in our first episode, we talked about the co-parenting, fostering relationship with the other side. They look at the resources that you have, the emotional needs of the child, the physical needs of the child. Who has a plan for the child's future? Who has a plan for the child's emotional health in the future? So those are all types of factors that the court is looking to hear when they're dealing with a custody case and making a determination. What is in the best interest of the children?
So along those lines, if we're talking about the best interest of the children, what does the standard mean and how does it influence custody decisions?
The standard is, there is no standard. Let me not say it like that. But the standard is what we call the best interest of the children. And when you say what's in the best interest of the children, there's this broad scope that you're dealing with. For example, we talked about, the desires of the children. Well, the courts have to weigh why the children desire one parent over another. And that may be because we have a Disneyland parent. The Disneyland parent is, whatever you want, we'll go wherever you want, let you do whatever you want, and there's no structure. And what kid wants structure? Of course they don't. So they're going to choose the Disneyland parent versus the parent that has rules, makes you do chores, do the things that you need to do so that when you grow up, you'll be a great adult in society. That is the standard, quote unquote, that you have in the family law arena for making decisions for what parent is going to be the parent to name the residence of the child.
Okay, so how do Texas courts handle joint custody arrangements? And what are the advantages and the challenges of such an arrangement for parents and the children?
A lot of times we talk about joint custody, and I think I have to break that down a little bit. And the reason why I have to, you have what you call the standard possession order, and that's you still are both parties are still having access and visitation with the children. So when people talk joint, the average person is saying 50-50 custody, right? That means that they're like 1 week on, 1 week off, 1 week with one parent, 1 week with the next parent. Now, believe it or not, I find that 1 week on, 1 week off structure is very good for children who have special needs. For example, that they may have autism, because when autistic children need very strict structure. And so they can't, all this back and forth, 1 week on, 1 week off. Not 1 week on, 1 week off, but the 3 days, the following day, following week, 1 week, one Thursday of night, and then the next week they don't have anything, and then the next week they have a visiting schedule. That works best for an autistic children, for them to have a routine, have structure, and go back and forth. But some kids aren't wired that way. And so that may not be the best interest for them. They may like the standard possession order, and it fits best with them based on school, homework, etc. What parent is going to work with me in order to get my schoolwork done? The other parent may not do those particular things. There's also what we call like 2-2-3, Monday, 2 days. Monday and Tuesday, one parent has them. Wednesday and Thursday, the other parent has them. And then Friday, Saturday, and Sunday, the parents rotate which, parent will have them on the Friday, Saturday, and Sunday schedule. That one is a lot more changing, but it does work, especially for parents who have weird schedules. And so the courts can do a penumbrum of things to make things work for both parents and the children. There's even what we call like a DuPont schedule. And the DuPont, for people who work, in the oil fields, in plants that have weird schedules, we call it the DuPont schedule, because they get their schedule a year in advance. And that way, in a year in advance, you can tick off what days are going to work best for that parent to have visitation, because they may not have Saturdays and Sundays off. They may not have the standard Thursday overnight to have time with the kids. So it's better to make that agreement up front, give the schedule. Everybody knows what will happen for the entire year, and then you go from there. So the courts have broad discretion in deciding what type of visitation schedule should be best for the children. Now, as a practitioner, and this is just a lawyer point, sometimes we have a debate in the legal field as to whether or not the court actually has authority to issue a week on, week off schedule, because the legislation has been very clear on what they believe is in the best interest of the children, and that's your standard possession order. The standard possession order is the one where the parent one parent is the primary parent, the other parent has a visitation schedule. That visitation schedule is first, third, and fifth weekends of the month. A lot of people think that is every other week, but it's really not. It's the first, third, and fifth weekends of the month. They have during the school year, Thursday overnight to Friday morning when school resumes, and that's only during school time. And then they rotate Christmas, Thanksgiving, New Year's, and also spring break. The parent that is not the primary parent, who's the possessory conservator, will get 30 days in the summer. If they don't choose a date by April 15th, then the statute automatically gives them July 1st through July 30th, or July 1st through July 31st. And that is what the legislature has said what's in the best interest of the children. And so it's just, some courts will go out on a limb and say, I think that this is in the best interest and I'll do a 50-50, true 50-50 split. And others will say, I don't think that I have the authority to do that. So you have to really know your judges in order to make that determination of what's going to work for you.
Okay. And you touched on it a bit, but when a parent wants to change a custody arrangement, what does that process look like? And how hard is it to modify an existing custody order?
The first criteria to changing an order is to show that there's been a substantial change in circumstance. Well, what does that mean, a substantial change in circumstance? Could be I got married. Someone had to move away from the geographical restriction of Harris County, contiguous counties, or Texas, because the one party may be already out of Texas. So that modification has to show that there's been some change in circumstance that warrants a modification. For example, if there was something that was contemplated during the original order, such as, I'll give you an example, one of the cases that we had that went to a jury trial, there was a contemplation before the order went in that this parent was going to move from California to Texas. They tried to use that as a basis to say it was a change in circumstance, but we said it's not a change in circumstance because it was contemplated in the original order. There was language in the original order that showed in the event that this parent moved from California to Texas, we had this particular schedule in mind. So there we had this particular schedule. In that schedule showed that no, that's not really a change in circumstance. And so we were able to prevail in that particular case. But there's other situations and circumstance. You have two rules that really dictate modifications. The first rule is if you're trying to modify a custody order that is within 1 year of the last order coming into place, the final order coming into place, you have to show that there's a significant circumstance that affects the mental and physical welfare of the child. So it has to be some form of significant impairment that affects the emotional and physical health of the child. That's a very high burden that you have to face. And you would typically have to have, some expert to show that the psychological needs of the child, some expert to say that the physical needs of the child is not working based on this order. It's not just a cut and dry say, the physical, my children are emotionally suffering from this particular order. You can't do that. You have to reach that higher burden and show that this is significantly impairing the children. The other side is that this is the standard. Some things have changed. I moved outside of the county. I moved inside of the county. So now I should have more time with my kids. But once you prove up that there's been a change in circumstance, at that particular point, we go back to that standard, best interest of the children.
So how does Houston's family court system address cases involving parental relocation or one parent wanting to move out of state with the child?
I don't really like it. Let me just say that off the bat. In Harris County, they don't like parents that are moving out. And think about it. If one parent moves, that reduces the access that the other parent had to the children. And that's not necessarily, quote unquote, in the best interest of the children. However, there's been some case law and some other factors that the Texas Supreme Court has said, you need to look at this, whether the parent moving will enhance the living and lifestyle of the children, and that may be in the best interest of the children, that parent can do a little bit more financially by being able to move. Or you could show that this geo restriction is about moving for example, not only for a better job, but there's been occasions where people have moved in order to get married. Now, I've seen judges on one end say, okay, you more than welcome to move, but when it comes down to the children are going to stay here. And so as a parent, you have to make that determination of what you want to do if the court decides that they want to make the children stay here. I just recently even had a case where and we were dealing with a little one that's only about 6-7 months old. Mom just packed up and moved to Louisiana, and with the child, although the child was born, conceived, been here in Texas, she just decided unilaterally that she was going to move to Louisiana. Well, that didn't sit well with the court, considering for the first 4 months of the child's life, the dad was involved with the child every day. Matter of fact, the mother lived in his house for the first 4 months. Yeah. As the case progressed, the court just said, you know what? I'm going to flip custody because she moved to Louisiana and she needs to move back. If she moves back, may flip it back to her. But if she doesn't move back, managing conservatorship is going to go with dad. So you never know. You have to know your courts and your judges, really.
So why would you say it's important to have an attorney when dealing with child custody issues rather than trying to handle it by yourself?
Again, most people think that certain things will factor in a modification case. For example, there have been, I don't like the fact that she stays out too long. She has to get a sitter. Or I don't like the fact that he might have a girlfriend over and I don't know who that girlfriend is. And those type of things don't really factor into what's in the best interest of the children, unless that girlfriend was a molester or the person who was the babysitter for the mom was some type of abuser and abusing the kid. But those particular things really don't factor in and weigh in. So you need an experienced attorney to know what particular factors are going to be germane in moving the court to change custody the way that you would like it.
This has been great. Thank you again for joining me today. It's always a pleasure chatting with you.
Thank you. I appreciate it as well.
And thank you for joining us for ALP Corner, Family Law in the Heart of Houston. Please be sure to like, subscribe, and leave a review on our channel.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.